And the prosecutor's job is to make you angry. It's to make you look like a hothead who would haul off and shoot someone when it wasn't reasonable. And if you fall into that trap, and as your lawyers, I mean, we're going to coach the hell out of you. Coach doesn't sound like the right word there, but you know what I mean. We're the Armed Attorneys. Today we were talking about what you can do in the courtroom to win your self-defense case and make that jury love you. Stick around. We're going to talk about our top 5 tips to kill it in the courtroom. But before we get started, show your support for the Second Amendment by hitting the like button.
And, this is a question a lot of folks get, or maybe they don't even consider when it comes to self-defense. Great. Preserve my life, preserve my loved one's life. All right. Well, there's a lot of things that happen in the aftermath of a self-defense incident. And for some of these things, especially in the cases of, like, let's say an accused murder, no statute of limitations, this stuff can have lifelong impact. And so you need to think about it a little bit.
Yeah. And I think we normally talk about, like, okay, how do I properly defend myself within the law?
Yep.
Good to know. And we talk a lot about what does a good lawyer do and what happens in the courtroom on the lawyer side. Good to know. But we don't often talk about what you, as the self-defender, need to do in the courtroom to help us help you.
Yeah, so we went through this, spent some time thinking about it, came up with our, hey, I got a new client. I wish they did these 5 things. And they're, we boiled them down to things that you have control over that could have tremendous impact on a self-defense case should you find yourself in that unfortunate situation. And that brings us up to number 5.
Right. Number 5 is you need to be measured and polite as much as possible on the scene, in the body cams, on the 911 call, and if applicable, in any interview with police.
With your attorney present.
With your attorney present. That's why if applicable, right? And so, but why is that?
Well, think of this. A trial is a theatrical recreation of what has happened.
Yes.
And it's hard. Obviously, time dilation, adrenaline dumps, all these physiological factors that are outside of our control. But I will say you have some control over this stuff, especially, let's say you have 5 minutes before the police arrive or a day before you're interviewed. Depending on how much those things are influencing it, you can have a lot of control over this. And the way that I talk to my clients about it, I say, just imagine that there's a camera floating around recording you all the time and that it's going to be played in front of a jury. Would you be embarrassed, or would you want this displayed to a jury? And, sometimes I say, nope, that doesn't make me look very good. Yeah. Ding, ding, ding. Exactly right. It's a theatrical performance at that point.
Yes. And whatever you have to do. I mean, sometimes when I'm composing a text message to a friend or a loved one, I have to remind myself, okay, if this had an exhibit sticker on it, how would you feel about it?
That's a good,
Yeah, I mean, and that's never applicable with my text message, but that's a good sort of rule of thumb to kind of calm yourself down and not fire off those fiery text messages that you feel like sending.
Sure.
But, think about however you need to do it, whatever you need to tell yourself in your head. If my child or my grandchild were right here listening to what I'm telling the police, how would I comport myself, right? Because in so much as you can, you need the jury to have, from the word go, the idea that you are reasonable, right? That's what we think about on all of self-defense law. Was this person reasonable? And if you're like, and comes from a real case that I'm going to try soon, if you're like, we used to string mother this up in this town. No. It doesn't matter if you did the right thing. That doesn't sound reasonable. And you don't want that to start to poison your jury against your reasonableness claim. So you got to just, whatever you got to tell yourself, think of it now, figure it out now, because you're going to have minutes?
Yeah.
Minutes.
Well, and these apply to every single state. There's not a state that doesn't require reasonableness in a self-defense case. So clearly that applies.
And there's not a state in which your own words cannot be used against you.
Yeah.
Always. Every rule of evidence in the entire country says your statement of a party opponent comes in. That's you. Everything you say comes in. Okay. And I'll apologize to Samir in advance. There's a lot of bleeping in this video, I think. All right. Number 4 is don't go posting on the social media.
Sure.
Don't do it.
I can't tell you, all right, when a jury is evaluating whether somebody's conduct is justified, they're looking at oftentimes the before, during, and after. Well, after, social media, those two things do not mix.
No.
One, things in writing, generally, lawyers don't like that stuff. Two, maybe it's an inconsistent version of events. Three, maybe it look like a hothead, unreasonable, all those things that we've already kind of talked about. I have never seen a post self-defense incident social media post help an accused.
No, never. And I have a case right now in which it has actually been very, very harmful to my client that he has gone and done this on the Facebooks while his case is pending.
Is he huffing and puffing?
He's huffing and puffing, and it has been a detriment to his case. So not just that, but I would say right now, so after the fact, your lawyer will remind you, don't post on social media, and then your lawyer will call and chew your ass out when you do it, and the prosecutor calls her.
Yeah, my least favorite thing is when the prosecutor emails me and says, "Hey, just so you know, your client is posting this material online."
Yes, so don't do that. But also, you can right now go back through your social media, figure out what sort of firearms or self-defense content you have posted, and if it is not extremely measured and extremely like, I've posted some gun stuff. I mean, maybe the shotgun range. I mean, there's some, pick your battles, right? But take it down now, because more and more often, I don't know if you're seeing this too, but you may, I am seeing like social media dumps while my client is still in the process of like bonding out of jail. I mean, they have the investigators on this so fast because they know that after the incident, you're probably going to go clean things up. So they want to get you before.
Yeah, and at a minimum, they're firing off these like preservation requests to Facebook, Instagram, TikTok, all these places to where, all right, maybe you do have an opportunity to go and clean it
up now.
But if they're preserving this stuff,
yes,
hitting delete doesn't work.
No, and I will say too, because this is where there's at least one keyboard warrior who's going to say a good lawyer wouldn't let that stuff come in. And we will remind you once again that a good lawyer can't do shit against a bad judge.
Yeah,
a bad judge makes that call.
Yeah, a judge is, they're the referee calling balls and strikes. If there's some relevant reason why this stuff comes in, the appellate courts, let's say they appeal this case, they're going to say, did the judge abuse their discretion? A social media post, I can't see a case getting overturned for a social media post unless it's wildly inflammatory, which, you're probably not going to be posting that stuff.
Right. So, I mean, yes, it might get overturned on appeal if an abuse of discretion, which is a pretty high standard. But bear in mind that if you are convicted of murder, where are you waiting for that appeal to take place, Richard?
Yeah, you're in custody.
You're in prison. You're already serving your sentence waiting for that appeal. So let's not get there, please.
Yeah. So don't post on social media post event. And that brings us to number 3, which is start recruiting friends and allies. I can't tell you how often this comes up. When you have a trial, these are public settings. They are open to the public, and courts have to make accommodations. Let's say there's a really high profile trial, and I'm sure you've seen this. They set up overflow rooms. They set up video cameras and they display it in a public place so that everybody has an opportunity to look at this stuff. Well, what happens oftentimes, victims' families, a lot of times in self-defense cases, these are complete scumbags, but they will fill up the courtroom.
Yes.
And
often they have very little to do.
Yeah. And so, what does a jury see? They look over, they see the state of Texas, they see a crying family sitting in the background, even though their person, let's say, was a complete POS, completely needed to be stopped because he was about to kill somebody. But then they look over to your side of the courtroom and the pews are empty.
Pews are empty. And unfortunate as it is, optics matter. And unfortunate as it is, juries feel pressure. They feel that pressure. So you got to start like, look, you guys are my people. And I know that you have jobs that are very important. I know that you may live all over the country, but this is the trial date. This is what I really need you to do. I need you to fly in. Also, and this is a conversation that every lawyer hates to have with their clients too, but recognize that if you are convicted of a very serious crime like murder, that is the last time you are going to see these family members, not through glass.
Yeah.
So, although a depressing family reunion, it is a good thing under lots of circumstances to get everyone rallied around you. And again, I wish that the optics didn't matter that much to the jury, but it does. And it's something that can be extraordinarily helpful to you.
Yeah. And it's a tough conversation. You have your neighbors, maybe folks in your church, maybe you're part of a club or, in the community. A lot of times folks are embarrassed. Hey, look, I'm charged with crime, this, but self-defense is a unique animal. This
Yes.
is I did it and I had a good reason to do it because I was preserving my own life. So, you know, it is a tough conversation, but that support is
Yep.
really, really important.
You need that extended family, pastors, neighbors, coworkers, all of it. All right. Number 2, keep your cool. Keep your cool in the courtroom. And it sucks because the state, the government, is telling the other guy's story. And lots of it is inaccurate. And what's maybe even quasi accurate is going to be skewed against you. But you cannot. I mean, what, like making faces, right? Great example.
Yeah, flashes of anger.
No, you can't even like shaking your head and furrowing your brows. No. And I know you want to, but you can't do it. The jury sees that and they just want, there's a reason your lawyers will tell you to remain completely stoic, impassive, attentive, yet
Yeah,
stoic.
I mean, my ideal client in a suit, clean,
Yeah.
clean dressed, thoughtfully watching the witness, writing notes down, not expressing opinions one way or the other. And here's what prosecutors do. They have an event, they weren't there. They get to fill in the pieces with videos and 911s and witness testimony. And then they kind of, they have this story in their head, and that's the story they're telling to the jury. I'll say this comes up a lot. Clients get distracted by really not important details, but they're just like, look, that proves that they're lying. They got this little detail wrong that's completely insignificant. And then whenever they start expressing their dissatisfaction or, showing like, idiot, he thought the car was red and it was really blue. It's like, okay, it doesn't really matter. That's not that important.
Right.
When they start seeing all that kind of reaction to non-material evidence, I'll say that is a huge turnoff for jurors.
It is, as is your anger or frustration on the witness stand, which as a self-defender, you are 99% of the time going to be up on that witness stand testifying and telling your side of the story. And the prosecutor's job is to make you angry. It's to make you look like a hothead who would haul off and shoot someone when it wasn't reasonable. And if you fall into that trap, and as your lawyers, I mean, we're going to coach the hell out of you. Coach doesn't sound like the right word there, but you know what I mean.
We're going to prepare.
We're going to prepare. We're going to talk about how you have to keep your cool. We're going to do practice cross-examinations with us, we do it with lawyers from our office who you don't know well. So it simulates, who are former prosecutors. So it's going to simulate sort of what you're going to get.
Adversarial.
It's very adversarial. We are going to drill it into you that you have to keep your cool. And yet they don't always keep their cool, Richard.
Well, and part of this is, and this is just complete lawyer training. I mean, we're taught to walk the person down the hallway, close all the doors, and there's only one door left. And so these lawyers, I mean, they have thought about this stuff in great detail. And I'll say, to the benefit of self-defenders, this doesn't come up very often in other cases. The truth is pretty stinking helpful in self-defense cases, and it makes the job a lot easier. But even with the truth on your side, these folks are trained. I mean, it's Larry Posner. He has incredible material on cross-examination. One of the goals of cross-examination is exhausting the witness so that they just give up and start agreeing with you. And so knowing these kind of tricks, preparing with your attorney, not losing your cool, that's so stinking important.
Yeah. And they're just going to try to make it like Leslie and I do this. Like if Leslie and I are cross-examining someone and we think that they have a problem with women, we're going to get really aggressive with them. Or if it's like, if you and I are trying a case, like I'm going to be the one who cross-examines them so I can prove to the jury that I'm right. Right.
Yeah,
I mean,
it doesn't look good when a man beats up on a woman on the stand.
No, but that's the deal, right? They're going to think about what is your weakness? What is going to prove to the jury that you are an asshole? And they are going to craft their entire cross-examination, even down to potentially who cross-examines you around that point. So they're not dumb. They know what they're doing.
And shout out to Edwin Walker. He has a very good cross-examination. He really wears witnesses down. He
does wear them down. He wears me down during cross-examination. Like, stop. It's over, buddy. I don't know. Anyway, that's just me.
All right. And that brings us to our number one tip, and that's be remorseful. Kind
of remorseful.
Yeah.
Yeah.
So
go on.
It sounds terrible. I mean, we talk about this, how to make a good 911 call, not saying things like, I'm sorry, or I know I'm getting arrested. Why? All right. There's kind of this consciousness of guilt implied in all that. So you don't want to be too sorry, but, juries don't like it when you say, yes, he deserved to die and I hope he burned in hell. They don't like that.
No. And that's one of the prosecutor tricks. When they get you on cross-examination, they're going to say, "Do you regret this? Are you sorry for what you did?" And if you say no, they're going to say, "He's a heartless, remorseless killer." And if you say yes, they say, "See, he knows he did wrong. He's got sorrow in his heart about what he did." So there's no right answer, which means you got to get the right answer out on the witness stand. You got potentially get the right answer out as early as that police interview if you've got your lawyer with you, but you have got to convey to the jury that you are sorry that you were forced to take a life.
Yeah, I mean the Kyle Rittenhouse case, I think he walked this tightrope perfectly. I mean, that is a very difficult. It's not fun being
No,
on a
it's
witness
not fun.
stand. But I think he did a masterful job of because that's one of the questions he asked. Did you shoot to kill him? And it doesn't sound like a trick question, but it really is, because it's either yes, so it's like, aha, you premeditated this. This was done in cold
You wanted
blood,
him dead.
or it's a no, I didn't mean to. Well, now that's not self-defense.
Yeah, you weren't scared.
You weren't scared. So you see how that's kind of a trick question. In the I had to stop the threat, perfect response.
Right. So, I mean, it is, you need to be ready. And again, this is something your lawyers will help you with, but ultimately it's up to you, because my voice can't come out of your mouth while you're sitting on the witness stand to be able to say every single day, I regret that I was forced into the position to take a life. It
Yeah.
is something that I will have to live with forever, and because I mean, the jury's got to see some level of, yeah, I killed someone. And that does, I mean, I know there are people out there who have been police officers who have been in combat, and how much weight there is to that. But the guys out there who are like, I mean, basically itching to shoot somebody when they
Sure.
kind of think about these scenarios, like, you need to know it will sit with you the rest of your life. It is a big weight, and the jury needs to see that you're a human being who does feel that, but also that you knew you had to do what you had to do, unfortunately.
Yeah.
So,
But, there's a lot of stuff you can do. This is stuff you need to think about ahead of time. Don't come up with a plan when your ears are ringing and your eyes are adjusting to the flash of the
yeah.
muzzle in the dark.
But I will say, if you are currently charged with self-defense, you can review this video as well,
Yeah.
because you will, I mean, these are important things. Even if you've already had your incident,
Yeah, but
take these to heart.
just some food for thought. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, question, comment for us below. Until next time, we're the Armstrongs.